Hello,
Hi.
my name is Janice Snyder, and I'm from the County Council's office.
And my name is Rick Heyer, and I'm also an attorney in the Office of the County Council.
And we created this video to give you a basic overview of the requirements of the Brown Act.
So the Brown Act is California's open meeting law. And I think a good way to understand why we have the Brown Act and what it's about is to go back to what created it. And it starts from a series of articles that were published in the San Francisco Chronicle back in the early 1950s. That series of articles was called Your Secret Government. And the author of those articles went around to various counties and cities in the Bay Area trying to see government meetings, city council meetings, board of supervisors meetings, and the like. And every time he went to a meeting, he found a new obstacle. Sometimes he couldn't find where the meetings were held. Sometimes if he found a meeting, he wasn't allowed in the meeting. Other times he might get inside the meeting only to be told he couldn't talk. So of course he wrote up all those issues that he encountered in those articles. And from that, the legislature, specifically a legislator by the name of Ralph M. Brown, created what we now call the Brown Act to address those issues. And the Brown Act is that portion of the government code that requires meetings to be open to the public so that the public can participate in their government. It affords some basic rights to the public. Those rights include the right to speak, the right to have an agenda, to know what's going to be talked about, and to participate in their government. What is the heart of the Brown Act?
Well, the heart of the Brown Act is that basically in any situation where there's a majority of the decision-making body, that's considered a meeting under the Brown Act. And once you have a meeting, it triggers certain requirements. One of them is that a majority of the board cannot discuss or deliberate or take action privately about an issue that might become before the board. All those conversations need to be had in a public forum. So it includes private conversations, whether by in person, in telephone, by text, by social media, or any other means. It applies to several different meetings. It applies to formal meetings, briefings, retreats. It also applies to when you're out to dinner with members of the same board or having coffee or tea, any meeting of the majority of the board. The Brown Act makes certain those meetings that are outside the public purview as unlawful meetings. So that's any pre-meeting before a formal setting, afterwards, or serial meetings. So some explanation on serial meetings. And this PowerPoint slides are going to be made available to you. And so we're skimming them fairly quickly to give you a broad overview of what's permitted and what's not. And a serial meeting is any meeting in the majority of the board that could be simultaneous. That means everybody's, you have a majority of the board and they're all meeting together and they're talking about an issue that is subject to your youth advisory board. Or it's a sequential meeting. And these graphics kind of describe what that is. So A talks to B, talks to C, talks to D, and everybody is getting information about the same topic. That is prohibited. The other type of meeting that's prohibited is a hub and spoke. And that's when A, so I, Janice, then go talk to Rick, and then Janice, I talk to Joe, and then Janice talks to Mary, and collectively we're having a conversation, although not all together. We are doing sort of a hub and spoke and potentially gaining some collective concurrence on an issue. That is not permissible under the Brown Act. What is permissible is to talk about things that aren't subject-based, such as the date and the time of the meeting. But really the caution is to make sure that you're avoiding any significant conversations about an issue that might come before the Youth Advisory Board outside of the public setting. And there are some meetings, I guess not meetings, there's some gatherings that the Youth Advisory Board could be together, social events, attendance at an educational or seminar, as long as the members are not discussing board matters in those private settings.
So just before we leave the subject of meetings, it always helps me to think about meetings as having a couple of different elements. One element is there has to be a quorum or a majority of the body. So if you don't have a majority or a quorum, it's not a meeting. Then if you do have a majority or quorum and you're talking about a subject that could come before the youth advisory body, that the two things together are necessary to make a meeting. And as Janice said, that can happen in a variety of different ways. But if you're not talking about matters that could come before the youth advisory body, all of you could be talking about a basketball game or something at school or anything like that. It's only when you couple the majority with the subject matter that you have a meeting. And then the question is it lawful? i.e. it happens with all the basic rights I'm going to talk about now that the public has, or is it unlawful because it doesn't have those basic rights? And so what are the basic rights of the public? I mentioned a moment ago that the series of articles was about how those rights weren't afforded. Well, again, the rights that weren't afforded and the Brown Act is there to address is the public has the right to notice of the meeting. In other words, they get to know that a meeting is going to happen. They get to know the time, the place, and they get to receive an agenda so they know what is going to be talked about at that meeting. And they have the right to attend the meeting, to be present. Now, in the time of COVID, being present happens virtually most of the time. That hopefully will change soon. And so when it does change, people have a right to attend in person. The public also has the right to record the meeting. So they can have their phone up or any other recording device. And as long as they're not disrupting the meeting, they're perfectly in their rights to record what is being said by members of the body or anybody else that happens to be at the meeting. The public has a right to comment on things that are being discussed at the meeting. So if there's an agenda item, the public has a right to speak about that agenda item. And they also have the right to speak about things that are not on the agenda for that day. And the reason the public has that right is so that they can tell the body, in this case the advisory board, what are their concerns, so that the advisory body can hopefully, I shouldn't say hopefully, but could conceivably put them on an agenda in the future. And I'm sorry for bumping into you there. And the public has a right to see how every member of the body votes. So there can't be secret ballots. Every member's vote should be in public, and the public should be able to say, okay, Janice voted yes, Rick voted no, or however it goes. I won't get too much into the notice requirements, but it's enough to just say that it needs to be specific enough on the agenda for that the public understands the topic and, again, the time and place of the meeting. Again, the agenda items, it doesn't have to be very complicated, but it should give the public at least a general understanding of the topics that will be discussed. The public also has the right to written materials that are provided to the advisory body. So if there's a letter or there's a staff report or something like that, the public has a right to see that as well. Meetings, where can they be held? I mentioned this a little bit previously. When a meeting is held in person, when hopefully we get past this pandemic and we're able to be around each other in public settings, the meeting place has to be a place that is accessible to all. That means has to be compliant with the Americans with Disability Act. People that have mobility issues need to be able to attend. People also should be able to attend without having to fulfill any requirement like filling out an attendance sheet or saying the reason that they're coming. It's just enough that they're in the public, they have the right to attend. While we are in the pandemic, the legislature has specifically allowed, on a finding of the public health officer for the county, which we have, that it is necessary to have meetings virtually to mitigate the spread of COVID, that we are allowed to have, again, those meetings virtually over Zoom, and public can log on to those Zoom meetings, and through that medium, they are able to comment and, of course, listen to the proceedings. The public's right to comment. We mentioned when they get to comment. They get to tell the body how they feel, what they think, but they do not get to be disruptive. And it does come with a reasonable limitation on the time that they can talk. So the board says we're going to give everybody 2 minutes, 3 minutes to talk. That's a reasonable limitation. It needs to be applied uniformly, the same to everybody. But a body can put that reasonable limitation on the time. And the comments should be relative or relevant to the body. So youth advisory body, talking about mental health issues that impact the youth in our community, totally open to comment at the body. They want to talk about transportation in Yuba County. That's not really relevant to this body, so you could say those comments are not appropriate for this body, and ask them to limit it to things that are relevant. Lastly, the Brown Act comes with some consequences if it's not followed, and those consequences include, I should say, a potential misdemeanor if the violation is willful, but more importantly, or more likely, I should say, is that the violation might mean that any action the body took is null and void. So it does come with some very serious consequences, which is why this training is, I think, important.
And finally, just to repeat again, like we said, this video is just to be a very basic overview of the Brown Act and its requirements and how it applies to the Youth Advisory Board. There certainly could be specific questions that you have or issues that come up that our office is more than happy to answer. So connect with your county liaison for the Youth Advisory Commission, Youth Advisory Board, and we would be happy to help. And this was just to provide, now that you're serving on a public board, to explain sort of the responsibilities and duties that are required for making decisions, and hope that your board has a good onboarding meeting, and welcome. And again, if you have any questions, please refer them to our office.
Thank you.
Thank you.